Thank you, everyone, for joining us today. My name is Robert Sharpe. I'm currently Distinguished Jurist-in-Residence at the law school, having returned from my sojourn on the bench back to my academic home. I'm delighted to be moderating today's webinar, part of the Jackman series. We're going to be, of course, looking at or hearing about Friedland's new book, Canadian Criminal Law in 10 Cases. Now, before we start the program, I wish to acknowledge this land on which the University of Toronto operates. For thousands of years, it has been the traditional land of the Huron-Wendat, the Seneca, and the Mississaugas of the Credit. Today, this meeting place is still the home to many Indigenous people from across Turtle Island, and we are grateful to have the opportunity to work on this land. Now, we're going to be diving into a very interesting book, Professor Martin Friedland's latest book, Canadian Criminal Law in 10 Cases. I don't think Marty needs an introduction to this audience or any other audience, but let me just say that he is, of course, a graduate of the law school. He returned as a professor in 1965. He was the faculty's fourth dean from 1972 to 79. Marty has 2 doctoral degrees from Cambridge, a PhD and an LLB. He also has an honorary degree from U of T and other universities. He's a fellow of the Royal Society of Canada, a companion of the Order of Canada, and he's received a very long list of awards of distinction from the University of Toronto, the Canadian Association of Law Teachers, the Law Reform Commission, the Canadian Bar Association, and the Royal Society of Canada. From the Royal Society of Canada in 1995, he was awarded the Canada Council Molson Prize in Humanities and Social Science for outstanding achievements and exceptional contribution to the enrichment of the cultural life of Canada. Now, as we know, Professor Friedland specializes in criminal law, but he also is a noted Canadian legal historian, as well as being the editor of many, many long list of books, law review articles, and reports. And as I've said, he's going to be talking about his latest book. Marty plans to speak for about 45 minutes. Towards the end of the program, we will have a chance for question and answer. I would encourage you to submit your questions using the Q&A function at the bottom of the Zoom screen. And then I can go through those questions and make sure that they're put to Marty so that he can answer them. So you can enter those questions at any time. So without further ado, I invite Marty to start his presentation. And yeah, and I'm just going to ask you this, Marty. I've read the book, and it tells 10 very interesting stories. It tells 10 smaller stories, and it also tells a much bigger story. The bigger story, of course, is the history of Canadian criminal law. How was it that you got onto this storytelling method to relate legal issues and the development of Canadian law? Where did that come from?
That's a long story. Storytelling, in fact, came fairly late in my career. In the 1960s and 70s, I'd been trying to write a book on the development of criminal law in Canada, but I kept getting bogged down on specific topics. On a sabbatical in the early 1980s, I was working on one of those topics, codification of the criminal law. I looked at 2 draft criminal codes that had been produced in England in the 19th century, one written by the well-known jurist James Fitzjames Stephen, and another, and a much better code written by a British judge, R.S. Wright. This became an article published in the then new Oxford Journal of Legal Studies that told the story of the 2 codes and the interesting relationship between Stephen and Wright. My writing style had changed. I did not disclose to the reader at the outset what happened to the codes. This kept the reader interested in continuing to read the article. I liked the storytelling technique, so I gathered did readers. I then wrote a book, The Trials of Israel Lipsky, about one of Justice Stevens' murder cases, but did not tell the reader at the outset whether the accused was hanged or even whether he was convicted. Again, there was a measure of drama and suspense. John Mortimer of Rumpole of the Bailey fame gave it a great review in the Sunday Times. So I became hooked on storytelling. Two other true crime books followed using a similar technique. I used the storytelling method for my history of the University of Toronto, and recently in the W.P.M. Kennedy biography. After my book on Kennedy was completed in 2019, I was looking for a new project when a friend, historian Chris Moore, mentioned over lunch that he was thinking of doing a book on 10 civil rights cases. It immediately struck me that I should consider writing a similar book on criminal law cases. This is that book. After 6 decades and many grants, I finally have my book on the development of criminal law in Canada. How did I select the cases? I wanted the cases to be significant turning points in the development of the criminal law, covering a wide range of issues. I also wanted them to be factually compelling, and if possible, that there be a flow from one case to another, with interesting legal characters appearing and sometimes reappearing. I started with 10 cases, but the number of cases kept growing. At one point, I had a list of 25 potential cases. I began drafting the first few chapters. The draft of the first case turned out to be over 10,000 words, and the second case on Louis Riel, over 15,000 words. This would have made the book too long, so I decided to keep the number of principal cases to 10 and bring in other cases where appropriate. So it is, in fact, a book of many cases.
Okay, so tell us about some of these cases. I found it very interesting when I read it, but tell us about.
Well, I'll go through the chapters fairly quickly. Regina versus La Liberté was selected as the first case because it was the first criminal law case argued at the Supreme Court of Canada, which had been established in 1875. The trial took place in the Eastern Townships in Arthabaska in 1876. I didn't know about the La Liberté case until I started the project. It was also important because a future Prime Minister of Canada, Wilfrid Laurier, argued the case at all levels, a fact not apparently known by Laurier's many biographers. Laurier was the defense counsel at the 1876 trial before Justice Plamondon and a jury in Quebec where Laurier had his practice. Then before the Quebec Court of Appeal in Quebec City, and finally before the Supreme Court of Canada, which had been established in 1875. There was an appeal because there was a dissent in the Court of Appeal. The court held its hearings in the library of the Senate in the recently constructed Parliament buildings. All the principal cases in the book, except for Riel, are Supreme Court cases. The case is also of importance because the main issue in the case, to what extent can a complainant in a sexual assault case be questioned about her previous sexual conduct, is one that still plagues the criminal justice system. In the past few years, there have been over a dozen Supreme Court of Canada decisions on this very issue. The trial judge hadn't allowed any questions about the complainant's prior conduct, and La Liberté was convicted. The decision was upheld on appeal. The Supreme Court in La Liberté, however, dutifully followed the English law at the time and allowed questions about prior conduct, but didn't compel the complainant to answer the questions. Laurier therefore won the case, and La Liberté was set free. The unanimous decision was written by Chief Justice William Richards from Ontario, who had been a Liberal. As Ian Bushnell has written, there was, quote, a definite Liberal tone to the bench. This did not hurt Laurier's chances on the appeal. The bench knew that Laurier was about to be appointed to the federal cabinet. The pattern I used for this 1877 case was used for all the later cases. I describe how the relevant legislation came about, set out the background of the participants in the case, and introduced the political, social, and economic conditions of the times. In the La Liberté chapter, for example, I was able to discuss who has the constitutional authority over various aspects of the criminal law, why the Supreme Court of Canada was established, and examine the early Canadian law dealing with the law of rape, as it was then called. The British North America Act gave the federal government legislative power over criminal law and procedure. There is no doubt that the American Civil War was a major factor in the desire by many to place some of the more important powers and symbols of nationhood within the legislative authority of the federal government. At the Quebec Conference in 1864, Oliver Mowat, later Premier of Ontario, had commented on the advantages of a uniform system of criminal law and procedure. Quote, "It would weld us into a nation." I was also able to introduce other topics, such as whether the appeal courts could order a new trial. At that time, they couldn't on double jeopardy grounds. So La Liberté went free. That allowed me to discuss double jeopardy, the subject of my PhD thesis. For each chapter, I also trace future changes in the relevant legislation and the applicable case law. As lawyers know, the law about asking the complainant about her sexual activity has been through a long and difficult journey. Further, at the end of each chapter, I comment on how the process for developing the law can be improved. In this chapter, I question whether the Supreme Court should still be developing the law of evidence on a case-by-case basis. And as an aside, I note that two Supreme Court of Canada cases relating to the law of evidence were released yesterday. Why shouldn't we have a code of evidence, as the former Law Reform Commission of Canada and other bodies had proposed? Or perhaps we could do as is done in the United States and give the Supreme Court the responsibility of using its rulemaking power to propose changes in a federal code of evidence. In the US, the proposed changes are developed by an expert committee that reports to the Supreme Court, which then passes them on to Congress, and the changes automatically become law unless Congress rejects them. I also make the point in this and many of the other chapters that Canada needs a law reform commission devoted solely to the many important issues involved in criminal law, criminal procedure, and the administration of criminal justice, including sentencing and imprisonment. This would improve the certainty of the criminal law. Such a body would likely save society a lot of money. Courtrooms full of lawyers do not come cheap. The next chapter is devoted to the 1885 trial of Louis Riel. The Riel case is probably the best known and most written about criminal law case in Canadian history, and it had a profound effect on the future of Canada. One wonders what relations between Indigenous persons in Canada would be like today if Riel had been acquitted by the jury and had not been hanged. There were three main battles in the Northwest Territories in the spring of 1885. In the third battle at Batoche, the insurgents were overwhelmed by government forces, and on May the 15th, 1885, Riel surrendered. The trial was held in Regina in July 1885, which resulted in his conviction by a six-person English-speaking jury. Had the trial been held in Winnipeg, a mixed English-French jury of 12 persons would have been possible. The appeal in the case was to the Manitoba Court of Appeal and then to the Privy Council in England. There was no appeal to the Supreme Court of Canada because there was no dissent in the Court of Appeal. One consequence of the Riel case was that appeals to the Privy Council in criminal cases was soon abolished. Another major change was that Canada enacted a criminal code in 1892, in part because of the uncertainty in many areas of the criminal law. Riel was tried under an unrepealed British statute of 1351, and even Prime Minister MacDonald questioned whether the UK treason legislation was applicable in Canada. A criminal code, it was thought, would clarify such questions. We could, of course, spend all our time on this podcast on the Riel case. It's a complicated case. In brief, let me say that I believe that the trial was a miscarriage of justice. In particular, Riel's defense counsel did not put forward the defense that Riel wanted, that is, that his actions were justified. The Métis had serious grievances that had never been remedied. In a sworn affidavit before the trial, Riel stated that his actions were justified and that he wished to call witnesses to, quote, prove that the agitation in the Northwest Territories was constitutional and for the rights of the people in said Northwest, that without such witnesses being heard in court, I cannot make a proper defense to the present charge and will be deprived of justice. Riel repeated his plea for a defense of justification in his unsworn evidence to the jury. Defense counsel had not, however, introduced such evidence, and in his address to the jury, Riel's lead counsel, Charles Fitzpatrick, dismissed the defense of justification, stating, quote, "No one of any nationality, of any creed can justify the rebellion." That was, in fact, the defense that Riel wanted. Instead, the defense argued that Riel was legally insane, but produced weak evidence of legal insanity. Defense counsel Fitzpatrick, later the Chief Justice of Canada, had a clear conflict of interest. He was in the same law firm as the Minister of Militia and Defense, and indeed was the minister's brother-in-law. Further, the trial judge, Magistrate Hugh Richardson, was the legal advisor of the Northwest Territories while he was a judge and was actively involved in earlier steps in bringing in the military. Unlike Superior Court judges at the time, he did not have security of tenure. The main argument before the Privy Council put forward by the defense team was that the federal legislation that permitted a trial for treason by a magistrate with a 6-person jury was not constitutional under the British North America Act. But that argument couldn't succeed, and the defense counsel knew it, because earlier that year, after Riel had been charged, and just before his trial, the Privy Council had turned down that very argument in a murder appeal from the Northwest Territories. Finally, the government rejected the jury's recommendation for mercy and did not accept the conclusion given by one of the doctors who examined Riel at the government's request before his execution, that Riel was, quote, "not an accountable being." Yet an 1886 government report deliberately omitted those words from the published medical report. The trial, I believe, was a miscarriage of justice. The next case, Regina versus Union Colliery, involved a train crashing into a deep gorge on Vancouver Island in 1898 after the collapse of a rotting wooden railway bridge with significant loss of life. The railway was owned by a mining company, Union Colliery. Some of the passengers or their families successfully sued for damages in civil cases. In addition, the province brought a criminal prosecution against the coal company. One of the defense counsel in the case was U of T Law School graduate Lyman Poor Duff, later the Chief Justice of Canada. One of the reasons for including this case in the book is to allow me to explore in some detail the issue of codification of the criminal law in Canada through the enactment of the Criminal Code in 1892. The case involved the interpretation of the code. Canada, as I mentioned earlier, had adopted James Fitzjames Stevens' Code, and not the far better code drafted by R.S. Wright. Union Colliery was one of the first Supreme Court of Canada cases to interpret the new code. There were, in fact, very few Supreme Court cases in those earlier years. Not only did an appeal require a dissent in the Court of Appeal, but a case could not get to the Court of Appeal unless the trial judge was willing to reserve a case to an appeal court, and trial judges are not always anxious to have their decisions appealed. The 1892 code was overhauled in the 1950s. A further overhaul of the code was prepared by the Law Reform Commission in the 1970s and 80s, but as I note throughout the book, the Law Reform Commission was unfortunately shut down in 1993, and the revised criminal code was abandoned. The key question in the Union Colliery case was whether a company could be criminally liable for a criminal offense such as manslaughter, which requires a mental element, or what lawyers call mens rea. The trial judge permitted the charge, the jury convicted Union Colliery, and the judge imposed a fine. The Supreme Court of Canada held, in a judgment by Chief Justice Robert Sedgwick, that the company could be convicted of manslaughter, but not through the criminal code, but rather through what are referred to as common law crimes. The 1892 had not eliminated common law crimes. They were finally abolished in the 1953 revision of the code. Over the years, as law students know, Canadian courts, unlike those in the U.S., gave a very narrow scope to corporate criminal responsibility. The persons responsible for the harm had to be, quote, the directing mind and will of the company. As a result, there were very few prosecutions brought over the years relating to workers' safety. No criminal prosecutions, for example, followed the 1992 Westray mine disaster in Nova Scotia. Later amendments to the criminal code have, however, significantly expanded corporate responsibility. The penalties now available and conditions that can now be imposed on corporations, such as preventing a company from bidding on certain contracts, have expanded. I conclude the chapter by stating that Canada needs to devote more resources to the study of how to gain greater compliance with the law. This could be added to the scope of the work of a new law reform commission. The next two chapters, Manchuk and Beaver, cover aspects of the criminal law over a wide period. Both accused spent time in Kingston Penitentiary. Appeals to the Supreme Court were very limited in the first half in criminal cases within the first half of the 20th century, and so there were only one or two Supreme Court of Canada cases a year from 1892 until the jurisdiction of the Supreme Court widened in 1948, dealing with criminal cases, to give the court the ability to select the cases it wished to hear. Manchuk and Beaver dealt with fundamental issues of criminal justice. Manchuk, decided by the Supreme Court in 1938 in a decision delivered by our friend Supreme Court Justice Lyman Duff, adopted the language of the House of Lords in Wilmington that, quote, throughout the web of the English criminal law, one golden thread is always to be seen that it is the duty of the prosecution to prove the prisoner's guilt beyond a reasonable doubt. Though, while this was normally the standard of proof used in Canada before Manchuk, it was not uniformly required, particularly with respect to defenses raised by the accused. Beaver has always been one of my favorite cases. As every law student knows, the Beaver case, decided in 1957, required the Crown to prove mens rea, that is, a guilty mind. One can picture the Beaver brothers selling a drug, heroin, to an undercover agent on the hill behind Castle Oma. But in fact, it wasn't a drug they were selling. It was simply a harmless white powder. They were trying to punish the buyer, who they believed had double-crossed them in an earlier trial. The brothers were convicted and sentenced to 7 years imprisonment, and also declared to be habitual criminals with an indeterminate term of imprisonment. The case went to the Supreme Court of Canada. I learned about the case in my first week of law school in 1955, when the defense counsel in the case, Charles Dubbin, with whom I later articled, gave a special lecture about the case. The Supreme Court of Canada, in its new home, agreed that the defense counsel that the section should be interpreted to require mens rea. The Beavers, the court held, had to believe that the substance was a narcotic, which of course they didn't. So the case established an important principle of criminal law and is often cited in other judgments. Unfortunately for the Beavers, they had also been charged with another offense in the criminal code, making it a crime to sell, quote, any substance represented or held out by such person to be a drug. So their convictions were upheld and they remained habitual criminals. I happened to meet Louis Beaver in Kingston Penitentiary in the early 1960s on a visit with students. The Beaver case is a particularly good case for my purposes because it allowed me to outline the origins of the various acts relating to narcotic offenses and habitual criminals, and to discuss the defense of entrapment. Further, the case allowed me to discuss the so-called halfway house between absolute liability and mens rea that was permitted by the Supreme Court of Canada in the Sault Ste. Marie case in 1978. This is a good example of tucking a leading case into an earlier case. I conclude the chapter by arguing that the criminal code should spell out what the mental element should be for each element of an offense, just as is done in the American Law Institute's Model Penal Code, which has been widely adopted in the US. The Truscott case would, I believe, make it on everyone's list of the top 10 cases. It clearly demonstrates the frailty of the criminal process. In 1959, 14-year-old Stephen Truscott was taken into custody for the murder of 12-year-old classmate Lynn Harper, whose body had been found the previous day in a nearby woods. She had been sexually assaulted and strangled with her own blouse. Truscott's case had started in the juvenile courts, but had been transferred to the Ontario Superior Court. In September 1959, a jury in Goderich, Ontario, found Truscott guilty of murder with a recommendation for mercy. He was sentenced to be hanged, the only possible sentence that could be imposed by the trial judge at the time. An appeal to the Ontario Court of Appeal was dismissed, and the Supreme Court of Canada refused leave to appeal. Cabinet then commuted the sentence to life imprisonment. Doubts about his guilt started to appear, spurred on by a book on the case. As a result, the federal cabinet requested that the Supreme Court of Canada hear an appeal. The great criminal lawyer, G. Arthur Martin, presented the appeal. In 1967, the Supreme Court of Canada turned down the appeal with a strong dissent by Emmett Hall. Truscott was released on parole in 1969. In the 1980s and 90s, there was a growing acknowledgement by the judiciary and others of the frailty of the criminal process. In Canada, the miscarriages of justice in the well-known trio of cases, Marshall, Milgaard, and Moran, had made the public and the judiciary more receptive to recognizing this fact. Moran was studied by a royal commission which recommended that an independent review process be established by the federal government. A review system was then set up within the Department of Justice in 1993. In that same year, a new independent group, presently named Innocence Canada, was established and advocated that Truscott and a number of other suspect cases be re-examined. A report by Justice Fred Kaufman in 2002 examined the Truscott case, and as a result of its findings, the federal government ordered the Ontario Court of Appeal examine the evidence. In 2007, a strong and unanimous Court of Appeal, chaired by Chief Justice Roy McMurtry, ordered that Truscott be acquitted. One of the main evidentiary issues at the original trial was the time of Lynn Harper's death. A pathologist had testified at the original trial about the time of death, which made it likely that Truscott was the killer. However, sometime before the appeal to the Supreme Court of Canada, the pathologist had what he described as, quote, an agonizing reappraisal of his evidence. But he did not give it evidence on that appeal, and Arthur Martin was not told of the pathologist's change of view. There have been other examples of miscarriage of justice in Canada. Following a recent 2021 report, recommend the establishment of an independent miscarriage of justice review commission. My colleague Kent Roach was its research director. The federal government introduced legislation which is now going through Parliament. This new body will be a welcome addition to the Canadian criminal justice system. Chapter 7 of the book deals with morality in the criminal law by examining two cases, Clippert and Morgentaler. Most listeners know about the many Morgentaler cases on abortion. Few know about the Clippert case on homosexual conduct. In 1965, 39-year-old Everett Clippert, a mechanic's helper, signed a confession and then pleaded guilty before a magistrate in the Northwest Territories to 4 counts of gross indecency for committing homosexual acts with consenting partners. Several years earlier, he'd been sentenced to 4 years in the penitentiary on a similar charge. Following his guilty plea in the later case, he was sentenced to 3 years imprisonment in a penitentiary. Several months later, the Crown brought a successful application to have Clippert declared a dangerous sexual offender, which, if successful, meant an indeterminate period in a penitentiary. The Supreme Court of Canada, by a majority of 3-2, dismissed Clippert's appeal. This was the catalyst for adding provisions to a pending 1969 omnibus bill. The United Kingdom had recently enacted legislation liberalizing homosexual conduct. The omnibus bill was enacted by Parliament. Similarly, the 1969 Act partially legalized abortions. Abortions were still prohibited, but the law would not apply when it was performed in a hospital by a medical practitioner, etc. Dr. Henry Morgentaler had been performing abortions in his Montreal office before the act was passed and continued to do so after its passage. There were 3 Supreme Court of Canada cases involving Morgentaler. The first was in 1975, which dealt with a number of issues, including the defense of necessity and whether the abortion law was contrary to the Canadian Bill of Rights. Morgentaler lost that case. A second case in 1988 relating to abortions performed by Morgentaler at a clinic in Toronto struck down the 1969 abortion legislation under the Canadian Charter of Rights and Freedoms. A third case in 1993 related to whether a province can regulate abortions. It can't. Brian Mulroney's government introduced legislation expanding the grounds for an abortion, which passed the House of Commons, but in a tied vote did not pass the Senate. In the end, the cabinet decided to leave the matter as it was. That is, there would be no legislation. No government has attempted to pass legislation. In the United States, as we know, attacks by the right on the abortion law as set out in Roe v. Wade resulted in that case being overturned by the United States Supreme Court. Canada is very unlikely to follow the American path. The Charter, enacted in 1982, has had a profound effect on the subsequent development of the criminal law in Canada. As a result of the Charter, the Canadian judiciary became more engaged in judicial lawmaking than previously, and the Law Reform Commission of Canada, which had been given the task of reforming the criminal law, was thought to be less important and was shut down. Hunter versus Southam, decided in 1984, was the Supreme Court of Canada's first significant criminal law charter case. The case concerned the validity of a search warrant issued as part of an investigation into an alleged breach of the Federal Compounds Investigation Act. The Supreme Court held that the warrant was invalid under the search and seizure section of the Charter. There were 2 main defects. The legislation did not require that the prior authorization be given an entirely neutral and impartial manner, and did not set out standards on which a warrant could be issued. At the time, the Law Reform Commission of Canada had been developing new search and seizure provisions. The court likely assumed that the government would implement the comprehensive legislation. Supreme Court Justice Antonio Lemaire had previously been the chair of the commission. Unfortunately, the government did not act as the Law Reform Commission reported and so the courts, following Hunter and Southern, were left to develop the law of search and seizure. Chief Justice Brian Dixon had, however, specifically stated for a unanimous court that Parliament should not leave all the work to the courts. He noted, and legislators should be reminded of his statement from time to time, quote, "While the courts are guardians of the Constitution and of individuals' rights under it, it is the legislature's responsibility to enact legislation that embodies appropriate safeguards to comply with the Constitution's requirements. It should not fall to the courts to fill in the details." One of the major themes in my book, as I've already noted, is Parliament should play a greater role in developing the criminal law. Parliament, through bodies like the Department of Justice, a future criminal law commission, and parliamentary committees, can conduct empirical research. These bodies can produce reports and interim reports with draft legislation, hold hearings, modify the rules before implementation, fine-tune them further through regulations, and later amend the legislation. Courts obviously do not operate in that way. A second significant early charter case that I deal with in the chapter is BC Motor Vehicle Act, decided in 1985. The case gave a generous interpretation to Section 7 of the Charter, a section dealing with fundamental justice, which reads, "Everyone has the right to life, liberty, and security of the person, and the right not to be deprived thereof, except in accordance with the principles of fundamental justice." The case was a reference by the BC government to the courts asking whether the BC legislature could legally make the offense of driving without a license an absolute liability offense, and whether the accused could be sentenced to imprisonment for a first offense. The court held that it would be a denial of fundamental justice to sentence the accused to imprisonment in such a case. The concept of fundamental justice has subsequently been used in a wide variety of cases, such as the law of abortion, assistance in dying, prostitution, sentencing, and prison conditions. Section 7 is arguably the most important section of the Charter. I end the chapter by stating that the Supreme Court's generous interpretation of section was a positive development. In the second last chapter of the book, I examine a number of procedural issues that are affected by the Charter, including delay, disclosure, and bail. I do not have time here to go into those issues, except to note that disclosure has been well handled by the courts, and bail by the combination of legislation and judicial guidance. The solution to the important issue of delay remains uncertain. I favor legislative guidance. The final chapter deals with the 1999 Supreme Court decision of Regina versus Gladue, the key Canadian case on the sentencing of Indigenous offenders. It was a unanimous judgment written by Justice Peter Corey and Frank Iacobucci. The case is important because for the first time, the court interpreted Section 718 of the Canadian Criminal Code. That section was part of a major overhaul of the law of sentencing enacted by Parliament in 1995. After stating in Section 718.1 that a sentence must be proportionate to the gravity of the offense and the degree of responsibility of the offender, the section goes on to state that, quote, an offender should not be deprived of liberty if less restrictive sanctions may be appropriate in the circumstances, and all available sanctions other than imprisonment that are reasonable in the circumstances should be considered for all offenses. And then the code adds these important additional words: with particular attention to the circumstances of Aboriginal offenders. Jamie Gladue, an Indigenous woman, pleaded guilty to manslaughter of her common law husband. Her counsel did not, however, raise the fact that she was Indigenous. She was sentenced to 3 years imprisonment. Report after report over several decades had documented the high rate of imprisonment of Indigenous persons. The Supreme Court noted in Gladue, if over-reliance on incarceration is a problem with the general population, it is a much greater concern in the sentencing of Aboriginal Canadians. The court continued. In the mid-1980s, Aboriginal people were about 2% of the population of Canada, yet they made up 10% of the penitentiary population. In Manitoba and Saskatchewan, the court went on to say, Aboriginal people constituted something between 6 and 7% of the population, yet they represented 46% of the provincial admissions, and in Saskatchewan, 60%. The Supreme Court went on to state, these findings cry out for recognition of the magnitude and gravity of the problem and for responses to alleviate it. The figures are stark and reflect what may fairly be termed a crisis in the Canadian criminal justice system. The issue was revisited by the Supreme Court in 2012. The court found the situation was worse than ever. Since then, the situation has not improved. Former Justice Harry Laforme, the first Indigenous appellate court judge, stated in 2021, today, while Indigenous people represent about 4% of the Canadian population, they represent about 37% of the prison population. At each stage in the criminal process, Indigenous persons are disadvantaged. The chapter discusses many of the specific criminal justice issues that need to be studied to reduce incarceration. So, I conclude by stating there is a lot to be done to improve the criminal justice process in Canada. I welcome your questions and comments. Thank you.
Well, thank you, Marty, for a fascinating tour of criminal law in Canada throughout our history. I'm just going to ask you this question. If you had to pick one chapter that was your favorite to write, that you enjoyed the most, which one would it be? Or is that possible?
Well, actually, the first chapter, La Liberté, I found quite fascinating. First Supreme Court of Canada case, and you can picture the future Prime Minister arguing that case. And so it allowed me to talk about some things that really interested me. The charter chapter is probably the most important in that it's so important in Canadian society today, as you show in your book on the Charter of Rights. The one of most immediate importance is the last chapter on how we handle the large number of Indigenous persons and Black people in the criminal justice system.
Okay, well, thank you. That brings us to the end of our hour. And so on behalf of everyone who's listening, let me thank you very much, both for this lecture and for your remarkable career and contributions to Canadian law. And for those who had the pleasure of being your students, inspiration. So thank you very much. I'm sure many of your students are in the audience.
Yes.
Thank you.
Thank you. It was a pleasure giving this talk.
Thank you.